healing.
State of Michigan versus Misty Cruz, 231365.
Your Honor, I'll talk quietly because I'm sure you're.
I'm sorry. Oh, no, I don't want you to be quiet because then we can't pick you up on the recording here.
Thank you, Your Honor. Kevin Thompson, appearing on behalf of Misty Cruz, who stands to my right.
Thank you. And your name, please.
Misty Cruz.
Are you picking her up?
Yes.
Okay, thank you. And thank you for addressing appropriately for court. So two things. First, counsel, I wanted to address a couple things. Number one, it's my understanding that your client did not turn her firearms over to the Riverview Police Department as ordered as a condition of bond by this court. And that you have them for safekeeping.
I do, Your Honor, and I will abide by the court's order to turn those over.
That is what the court required. And in fact, the court required that at the date of arraignment. And the court indicated they were to be turned over to Riverview Police Department for safekeeping. And quite honestly, counsel, you don't have the authority to not comply with the court's order. If there's something that you would like to file a motion on for those to be returned to your custody during the pendency of this action, then that's the time that you would request that. But those absolutely should have been turned over to Riverview Police Department as soon as she was released.
And Your Honor, I apologize for that. I wasn't retained at the time. I immediately filed a motion when I was retained with the court. It's been my practice. I work with prosecutors that typically we're allowed to safekeep property for clients. I do apologize to the court for that. Since my motion is coming after that. I will abide by the court's order.
Well, yes, and quite frankly, counsel, and I can understand that there may be courts and other and prosecutors and stuff that you work with that may do things differently. However, if you're filing an appearance in a matter and you're at a court and you're unsure of something, number one, you can contact the court to find out, and number two, there's a court order. Unless that order is changed, that order stands.
Understood, Your Honor.
And so you have those firearms now?
Yes, they are locked up in the safe at my office.
Okay, I feel like there are some other issues that you're opening yourself up to, but those have to be over to the Riverview Police Department by noon.
All right, 10 o'clock hearing in Dearborn. Could I have until 2 p.m.?
2 p.m.
Thank you, Your Honor.
They must be over there, and please do not allow that to happen again. That's not acceptable.
Understood, Your Honor. Yes.
Okay, all right, let's go on the record in the matter of the state of Michigan versus Philip Cass, 231958. Good morning.
Good morning, Your Honor.
Good morning.
John Gold, 30758, on behalf of Cass.
Okay, so today is the date scheduled for sentencing on your client's plea to an amended charge of operating or visibly impaired by alcohol, an amended charge of failed to report, and 2 counts of failed and stop property damage accident, correct? All right, and then the IVAC and the OWI and one of the leaving the scene of an accident were dismissed. Okay.
That is correct, Your Honor.
And do you have an opportunity to review the report and recommendation? There is an amended report. And so did you have an opportunity to review that with your client?
Yes, we did, Your Honor. We have discussed this matter. In fact, we discussed this in detail. With respect to the amended report, there were no changes in the body of the report, only that in the victim's impact statement, there was a VAC, the original one, of 0.16. The amended one indicated is 0.37. I would like to address that as part of the sentence.
The 0.1, counsel, the 0.16 was typographical error. It was just something because, and so that is why there was an amended report done, because when I was reviewing this before the docket, I noticed the PBT that came to 0.33 and then there was a blood draw. So I was questioning where the 0.16 came from because I didn't see it anywhere. So Michelle, because when she wrote the report, didn't have the blood results present. And, so therefore, she got the blood results from records from the police department, and it confirmed a 0.37. So, Mr. Gopal, that's how that was just a typographical error with the 0.16.
Thank you, Your Honor. I understand that because we knew what the BHCs were. However, I still would like to address it at the time of sentence, not because of that error by the court.
Okay. And so, anything else as relates to the report, counsel?
Your Honor, as I indicated, I've had an opportunity to review this with Mr. Cox. He has taken full responsibility for this matter. He has not had any alcohol consistent with your court's orders. He has also made arrangements to attend AA meetings at a location on Oak Street because it's walking distance and he doesn't want to cause any problems. Would that be a correct statement?
Just stay off the road as much as possible. The Secretary of State's coming at me, that's the thing, so understandably so.
Okay. And when he's talking about, Your Honor, I assume he has a valid license.
I do have
And
a
there
valid.
are restrictions, et cetera, placed on him by the Secretary of State. Also, Your Honor, as I've indicated, this was an isolated incident. Clearly, it was not his mind, probably partially because of the alcohol. And more importantly, I'd like to address this. This was not part of a traffic stop. He was directed where the cause of action was this accident.
There were multiple.
Multiple. There was multiple accidents. And because of that, he went home. Well, he was at home when the police came, not because of that incident. He went home and the police came to his address. It's a high BAC breed total. He indicated to me at the time that we pre-trial this matter that he'd been home for a period of time and was shook up and continued to drink once he got home. So therefore, there was some consumption of alcohol at his residence. It's not part of the traffic stop. I only bring that to the court's attention because that clearly would add to the height of the alcohol and the alcohol system when the test was taken. Other than that, Your Honor, we've asked that the recommendation be adopted. I see that he is eligible for early release. And this is where I'd like to address the second amendment. Originally, in the pre-sentence report, the amendment was for 12 months probation. I'm assuming that the recommendation, which is now 24 months, was placed on there because of the high BAC. I would ask the court to take those things into consideration, including the drinking at home, that has admitted to. And hearing for those reasons, and we would ask that for those reasons that the recommendation of 12 months be adopted. Further, Your Honor, I know that Mr. Cass wishes to make a statement.
I've taken some liberties on my own. Historically, I've treated drinking and driving very much severity. This is an anomaly for me. I've already taken measures to pictures. I've bought a time release safe if I do plan on taking one. I'm allowed to drink in the future. That I won't have access to my keys for at least till noon the next day. Like my lawyer said, I've already made arrangements to start going to AA on Sundays at 8 o'clock at Oak and Fifth. I didn't really prepare a statement.
Well, I mean,
Just okay. And that's I've already taken this very seriously, and I understand, the well, the court's got the consequences, the court's gotta, the court's gotta do what you gotta do, and, but I as well taking this very seriously.
Okay.
Sorry for my mumbling, Your Honor,
No,
I'm nervous.
no, that's okay. I guess, Counsel, here's, it appears as though there wasn't much time that lapsed when the police were called to the time that they encountered your client. And so, while I can wholeheartedly, I'm hearing what you're saying, that your client went into the home and drank some more, which according to one of the witnesses, the witness was surprised your client didn't even exit the vehicle with how intoxicated he was. Even if your client had 1 or 2 drinks at home, it is already intoxicated state. And that's what you're indicating is what got him to the 0.37. He clearly was well beyond 3 times the limit even before that, and maybe even 4 times the limit even before that. And sir, you hit a vehicle. You hit one of those big trash cans that went into a vehicle. Like you drove up on a curb and hit the trash can that hit another vehicle. You're extremely fortunate that you didn't hit a person, that there wasn't more damage that was done. And over in the area where you live, sir, those are some tight streets. There could have been a person trying to get out of their vehicle, and you could have hit them and killed them. And it would appear to me that the fact that you were not hospitalized after your consumption of alcohol at this level will tell me that you have a significant tolerance. And that you drink quite often and a lot when you drink, based on the level and the fact that you didn't need any medical treatment as a result of how much alcohol you drank, and the fact that you were able to walk apparently and somehow operate a motor vehicle. So your statement that you drink every few weeks, I don't think is accurate. How often do you drink? Prior to this incident, how often were you drinking?
Historically, so my habits have changed this year since I've been seasonal. I've had more free time. A little bit of my drinking consumption has been up a little bit over the past few months. But historically, I didn't drink on school nights. It's very rare.
Okay. So let's get rid of history. Okay. Prior to this incident, how often were you drinking?
A couple of times a week, but it was significant amounts of booze, probably.
And a couple. What does that mean to you?
Maybe starting mid-afternoon if I don't have anything to do that day. Maybe 3.
Okay. So you said a couple times a week. How often does that mean to you?
2, sometimes 3.
Not more, not closer to 4 or 5?
No, ma'am. No, Your Honor.
All right, anything else, counsel?
No, Your Honor. I did note, Your Honor, that he would be eligible for early term, and I indicated part of the explain that.
Correct. Okay. All right, and so the court will indicate after hearing from counsel, hearing from Mr. Cass, and knowing that we did have one of the victims present earlier, although we didn't hear from that defendant or that victim, the court does find there's reasonable grounds to depart from MCL 769.5 further after reviewing the report and recommendations that would support that waiver. The court's going to indicate the recommendation is appropriate. The court will note 24 months probation. You are eligible for early discharge. I'll go over that in just a few moments, okay? And the court's going to state the following: you're not to violate any criminal law of any government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You're to notify your probation officer immediately of any change in address or employment status. Do not use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. You are to participate and enroll in outpatient substance use counseling. The rehabilitative goal for that condition is to assist you in providing coping mechanisms so you may maintain sobriety and prevent relapse, hopefully preventing this matter from happening again in the future. And you have to participate in the Man Victim Impact Panel. The rehabilitative goal for that condition is so that you can increase your understanding of the dangers of driving while impaired and to educate you about the consequences of such behavior. The court's going to indicate restitution. We don't have an amount of restitution at this point, so I'm going to indicate 0. If there is restitution request, then that will be scheduled for a restitution hearing. It appears as though Mr. Hoffman is trying to get restitution from your insurance company, sir, but I don't know that he's very successful in that. That's just what the report indicated. The court's going to indicate 15 days on the court workforce. The rehabilitative goal for that condition is so that you can further develop work and life skills and get back to the community. Sir, you may want to find some other employment as well, other than just seasonal. And the court's going to also indicate 45 days on the alcohol tether. The rehabilitative goal for that condition is to provide additional support in maintaining sobriety. Okay, any questions regarding the terms and conditions?
Yes, Sharon. Oh, so, I'm assuming I'll get a document that breaks all that down for me.
Yes, you're going to give a probation, they will give you all that
All
information.
right, so information about, what I gotta do with this tether will all be in there, correct? Because if so, then I can just use the document later. So
I'm sorry.
the tether's so is the 45 days from the day I got the tether or
No,
from the day?
it's from today,
Okay, just wanna know when I gotta give it back.
yes. Okay, as to the operative of visibly impaired by alcohol, the council, those are all concurrent conditions. It's not 15 for each count. $300 fine, $100 screening assessment fee, so $100 supervision oversight fee. That's $50 a month at 24 months. And since you're eligible for early discharge, some of that money may not be due. All right, cost of prosecution, $300. Crime victim assessment fee, $75. Justice system assessment fee, $50. Workforce is $600. That's $40 a day at 15 days. And so that total, $2,625. On the failed report count, $100 fine, cost of prosecution, $200. Crime victim assessment fee of $75. Justice system assessment fee of $50, for a total of $425. Leaving the scene of a property damage accident, count 3, $300 fine, $200 cost of prosecution. Crime victim assessment fee of $75. Justice system assessment fee of $50, for a total of $625. Count 4, $300 fine, $200 cost of prosecution. Crime victim assessment fee of $75. Justice system assessment fee of $50, for a total of $625. So the total so far, sir, without any restitution is $4,300. You did post a bond, $5,000 10% bond, correct? And so there's a balance of $450 on that. Do you have any other money to pay today?
My money is getting tight. I would be looking to set up a payment plan.
We'll do that if you have anything you can do.
Yeah, I could probably come up with something today.
Can you pay $100?
Yeah, I do $100.
You know, $100,
I
okay.
do $100.
So $550 today then, when we apply the bond. Balance of $3,750. How much can you pay per month and what day of the month works best?
Any day would be fine. The,
Can you pay $100 a month? Okay. And understand that you can always pay more. And you want to pay more once the court advises you whether you like to probation agent. Which day of the month?
Any day is fine, the first would be fine, or the,
Of each month, right?
Okay. Well, I wrote down October 13th. Is that
Very
right?
fine, right?
Okay. So $100 per month on the balance of $3,750, beginning October 13th. Sir, apparently everything was in alignment, that nobody was killed, injured, or otherwise. Once that tether is removed, sir, you will then have had, when's the last time you consumed any alcohol, sir? It would have to have been,
the night of the incident, Your
Yes.
Honor, the 8th, I believe.
yes. And so you are just over 30 days sober, and so by then you'll be almost 3 months sober. When that tether is removed, sir, in 45 days, make sure you're reaching out to your sponsor or otherwise, because that would be a difficult day.
Yes, sir.
All right, please have a seat over probation. Somebody will brief you shortly. But first, let me just indicate, as I did, that you are eligible for early discharge, so long as all the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations. All monies have been either paid in full, or you make good faith effort to make full payment. Okay?
Yes, Your Honor. Thanks.
All right, thank you. Have a good day. Let's go off the record for a moment.
Will you hand me my screen box?
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. And trust me, at the end of the day, I'm sitting up here, I'm the one that needs a drink.